Welcome to Courtside Commentary. I'm here with NCLA of Counsel Margot Cleveland, who is the principal author of NCLA's amicus brief in the case Trump v. Slaughter, which is currently pending at the U.S. Supreme Court. We have Margot here today to educate us all on what the Trump v. Slaughter case is about and to discuss some of the finer constitutional points that case brings up. Margot, welcome to the program.
Thanks so much.
So let's just start at the beginning. Can you briefly explain, sort of in straightforward terms, what the Trump v. Slaughter case is about?
Sure. So Trump v. Slaughter concerns whether or not the president has the ability to fire the commissioner on the Federal Trade Commission.
You're fired.
Absolutely. And as we know, he's fired several different agency heads. What makes this case unique is that back in the 1930s, I think it was 1935, the exact same issue came up with the firing of
Mr. Humphrey.
Mr. Humphrey, who by the time the case got to the Supreme Court had died, so the case was called Humphrey's Executor, and it was fighting over whether or not he should be paid or his estate should receive the payment.
Back wages, essentially.
Back wages, exactly. Here, though, they're fighting actually to be reinstated, to be put back onto the Federal Trade Commission. And since Humphrey's Executor was decided, in the last 10 or so years, we've had the Supreme Court narrowing what that case said. Mm-hmm. And by that narrowing, it looks like the Supreme Court is poised to say, we're going to overrule Humphreys. And that's actually one of the questions they asked. So it's looking at it twofold. One, does the president have the power to fire the head of a so-called independent agency, the Federal Trade Commission?
Right, and a multi-member agency too, right? Unlike Sailor Law, which involved the CFPB, or some of the other cases where they said, well, we're not going to extend Humphreys to the single agency head context.
And the reminder here is that Congress said you can only remove these commissioners for cause, and it would say, misconduct. There was other jargon that they used along those lines.
Inefficiency, neglect. Yeah.
Exactly. So the question is, does the Constitution actually give the executive this unilateral power to fire someone, whether or not Congress wants them to? So Congress said, no, you can't. And the president is saying, yes, I can. The Constitution said that I could.
Right. And so, NCLA has been trying to get a Humphrey's Executor case up to the Supreme Court for about 7 years, I think. But the court could have taken one of these cases at earlier periods of time. It has sort of assiduously avoided doing so. But I guess the fact that President Trump has fired a bunch of people makes it harder to avoid the issue now.
Absolutely, especially now that he fired a commissioner from the FTC. It really puts Humphrey's Executor squarely there. We had Justice Thomas in the past, either in concurrences or dissents. I think it was probably mostly concurrences, saying we need to just overrule Humphreys. It was wrong. It was wrong, and there was probably a lot of the politics of the time with President Roosevelt that was behind it.
Yeah, no doubt, and there may be some politics behind whether people think the president should be able to fire folks from these independent agencies now as well. So, why does the removal authority matter for these independent agencies? Congress set them up this way. It obviously wants them to have some sort of tenure protection. Why does the Constitution say maybe they shouldn't have it?
So you can look at it two ways. You can look at it from the separation of powers perspective, where the executive power is all vested in a executive, the president. And part of the executive power is executing the law, which is something that the Federal Trade Commission does. It files lawsuits to enforce the law.
That's pretty executive.
That is pretty executive.
Quintessential.
The executive power also involves issues of foreign affairs. And the FTC is also engaged in those types of activities with other countries. So from a pure separation of powers perspective, it really does matter. I actually see the second point being almost more important.
The foreign policy point?
No. Actually, the second point, that it matters from a perspective of our democratic republic and representative.
Self-government.
Self-government, exactly. When you have these agencies and the president cannot fire these individuals, then you are left with people making laws, enforcing the laws, who have never been elected by the people, and there's no check on it. So when I say it's somewhat more important, it's maybe less theoretical, but it's more fundamental to our constitutional system. And you see that time and again when people talk about the unelected bureaucrats. And if the president does not have the removal authority, that will instill this unelected bureaucrat in office that nobody elected, that the people who were elected, the president, can't remove.
Right.
So I think that fundamentally...
And they were appointed by somebody who was elected, but often to a 5-year or 7-year, or I think in the case of Federal Reserve governors, 14-year term.
Right. And I think there's also the difference between the appointment and the removal. Yes, we elected someone who appointed them, but we've since elected someone else. And the election should have consequences. So I find it rather interesting that part of this is probably politically based. They don't like Trump. They don't like what Trump is doing. But it might not be Trump next time. It would be somebody else who was elected, and votes should matter. Well,
and the Supreme Court isn't going to make this decision based on who's the president now. They're making the decision for the next 100 years, right?
Absolutely,
or
absolutely.
Longer, yeah.
And I think that we've seen a shift from Humphreys to now. Now we have originalism as the way to interpret the Constitution. And even justices who are liberal justices still at least give word service to originalism. So I think that you're going to see a turning to what does the Constitution say, what is separations of power as underlying the decision.
Sure. Well, you made reference to, or at least alluded to, the concept of the unitary executive doctrine, which is this idea that, which the Constitution states that executive power is vested in one president. Philip Hamburger has a recent article out where he makes another textualist point, which it's not just that it's vested in one president, but the Constitution also talks about the executive power, meaning there's only one executive power. So it's not as though if Congress creates a new agency, it's creating new executive power independent of the president. The only executive power is the president's executive power. So that suggests another reason why ultimately these folks need to be removable, I think.
Absolutely. And you just can't say that the Constitution had 3 branches with separation of power, but there was some, penumbra of power that wasn't given. If anything, the power that wasn't given went to the executive. And you would see that with, again, foreign affairs as well as the executing of the law. And if the concern is our executive has got too much power, then Congress should be passing the laws and dealing with the issues as opposed to, kicking it over to the regulators to come up with regulations, oftentimes without guidance that allows the unelected individuals to affect the country in hugely important ways.
Yeah, let's dig into that a little bit more, because I think that you've hit on something which is the reason why a lot of people are concerned about, and even folks who might like the president, but they might be libertarian in orientation, or they might just not trust executive power, and they might say, well, Margot, are you really sure that you want the president to have more power? That doesn't seem consistent with limited government. So can you explain that a little bit more about it's not so much the problem of this, if it's executive power, the president should have it. It's these other powers that maybe are where the problem comes from.
And this is where you have to remember what the agencies are doing. And we saw this in Humphreys, the decision. The Supreme Court spoke about these independent agencies which were doing quasi-legislative and quasi-judicial functions.
Right.
And that's not what they're supposed to be. That's not what they're supposed to be doing. Article 1 is Congress does the legislation. Yet then you will see the SEC, for instance, where the SEC will promulgate regulations that create new types of activities. For instance, the Consolidated Audit Trail, as an example, which has this
giant database of everybody's stock information.
Exactly, a giant database that has everyone's information in it. And the SEC is actually forcing us to pay for it, where the SEC's budget isn't even big enough to pay for this. So the problem is that the agencies are doing the lawmaking, doing the interpretation, because you'll have the SEC do enforcement actions, and they will have administrative law judges, as most agencies will have interpreting different things. That's the problem. It's not the executive having too much power.
Right. So when we talk at NCLA about unlawful administrative power, what we're really talking about is when these administrative agencies are using legislative power or judicial power. And so the solution isn't to take away the president's removal power, which is an executive power. It's to take away the agency's legislative and judicial power.
Exactly.
Yeah.
But the people who are saying we got to narrow the president's executive power are also usually the ones who want to expand the agency's power. And this, we touched on this a little bit in our amicus brief. This really goes back to a distrust of the populace. And it was a classist-based system that they felt that we needed experts. We can't let the voters make these kind of decisions. So we're going to have these agencies that are experts. But as we're seeing, they're not really experts in a lot of areas. They might be specialists, but they will oftentimes be siloed. And even if they weren't, the public still has the right to elect the president, and the president has the power to decide how he is going to execute the law.
Well, and we talked a little bit about this too, so these folks are appointed, but I don't think that we talked specifically about the appointments clause and the fact that the Constitution is silent about the removal power, but not about the appointments power. Can you speak to that and how that weighs in here with what the Supreme Court should decide in this case?
Sure. So in the Constitution, when it's speaking about the president and having officials that he appoints, it says with the advice and consent of the Senate. So we have that there. But
so the appointments power is constrained.
It's constrained.
He can't do it on his own.
He can't do it on his own. And it's not for everything. It's only for certain types of positions. Right. But it says nothing about the removal. And that had to have been a purposeful decision. Everything in the Constitution was a purposeful decision. And the silence tells you he has to have the removal authority. Otherwise, it would have been limited by what Congress could do, what Congress said he could do. It also ties in with the idea that the executive has to be nimble. He must be able to act when there's a circumstance. So if you have a circumstance where someone who went through this confirmation process has been proven corrupt or dishonest or just incompetent, the president needs to be able to immediately remove them, not allow them to do more damage, which would make sense for why our founding fathers did not say that Congress has to approve the removal as well.
And that gets back to the Constitution as well, the president's Article 2 duty to take care that the law be faithfully executed.
Right. And that the faithful execution of the law, he can't possibly do that if he has no power over the people who he is delegating for purposes of executing the law. If he can't remove that power from them, he can't possibly faithfully execute the law. It's impossible for one man to execute the law for the entire country. So he has to rely on other people, but he has to have the power to control them, or it's no longer the person that we elected who's doing it.
Yeah, I refer to it as the stubborn subordinate problem, right? So if you have somebody who isn't willing to do what you want them to do, if you can't fire them, ultimately you can't control them.
Absolutely. And of course, the pushback on that is, well, maybe what the president is asking them to do is not a good thing. That, again, we have a political process. First, he had been elected, and if it comes to that point, there is always the issue of impeachment that they can do if it becomes an issue.
Well, but Professor Nelson has suggested, well, but that's fine. If the president thinks someone should be removed, he can refer them to Congress and Congress can impeach them.
And again, that's another point about being nimble, that the president, and part of the reason the founding fathers put the executive in one person is to make sure that they had the ability to act promptly when necessary. So if you have to wait for the process for Congress to do it, that would be a problem.
even assuming Congress is not in control of the other party, right? So they might want somebody in a position to undermine the president if it's in control of the other party.
Absolutely.
So that doesn't seem like a very workable solution. So there are arguments from your article, 7 Reasons SCOTUS Needs to Declare Humphrey's Executor All Dead. Can you outline why you believe Humphrey's Executor is sort of ripe for being taken out now?
Sure. So in Humphrey's Executor, the court, from a fundamental level, was wrong. They ignored the idea of separation of powers. They also, from a factual perspective, said that the FTC was not engaged in executive activity. And the actual opinion itself contradicted that. In the opinion, it gave examples of what they do, and it included enforcement actions so that the FTC could issue decisions and go to court if necessary. It was right there in Humphrey's Executor, and that's a key executive power. But then you have to add on to that, since then, Congress has given the FTC more and more powers. I don't know how many federal statutes there are, but there's scores of them that the FTC is charged with enforcing.
And they can go into court themselves with their own lawyers on these actions. Some agencies have to use DOJ. When I was at the Consumer Product Safety Commission, we had to work with DOJ if we wanted to bring in certain kinds of enforcement actions, but FTC doesn't always have to do that.
They don't have to. And then you add to that the FTC can go to other countries and enter into agreements with other countries, under memos of understanding, other types of cooperation agreements. And when we're talking about foreign affairs, that is quintessentially the federal government, the executive's power to do. And one of the things that shocked me when I was working on the amicus brief was going to the FTC page and literally document after document of these agreements, and you click on them and it pulls up and it's signed by an FTC chair, the commissioner. So again, this is Humphrey's Executor was wrong when it was started, but it's even worse now. I think that you also see that Humphrey's Executor just cannot withstand scrutiny under originalism, where we have this separation of powers. And I think that the Supreme Court has really been kind of grappling with how do you return to originalism with agencies? They have these
which weren't part of the original design.
Right. You have non-delegation doctrine. You have just other different theories that they bring in to talk about whether the agency has gone too far.
Sure.
And
major questions doctrine.
Thank you. Yeah. That was the one I was slipping on. But those doctrines really are coming to the forefront, or created because they've lost the fundamentals of Article 1, Article 2, Article 3.
Lost the plot, maybe.
Yes, exactly. They lost the plot. So I see the Supreme Court seeing this as an opportunity to kind of put things back on an originalism path, which will make other cases easier to resolve because they don't have to come up with an exception or a rule or an exception to an exception to get to the right answer. They just return to the Constitution that gives it.
And if they find that these agencies are doing things that are outside of the executive power in a way that folks are concerned about the president being too powerful, they can trim those back. They can say, no, you can't do legislative power in the executive branch.
Right.
They have the power to do that.
They absolutely do. And you also have Congress has the power to do that. If Congress wasn't trying to delegate it to the agencies, then we wouldn't have any issue. But the courts are still a check on that when Congress is doing these very broad, generic delegations of authority, that's something the courts can say, no, you can't do that. That's legislative power, or the deference that we saw with Loper-Bright and other cases, that they are restricting what agencies can do. And that's part of the reason I think that Humphreys is taking us back to ground zero for it.
Any other arguments that you wanted to mention from your article, or?
I don't think so. I think that, it's a good background read for people, but it'll be interesting to see the actual argument and what the judges key in on. I would not want to be arguing on Slaughter's behalf because it's going to be impossible to say they're not engaged in executive function.
Right. And then once you concede that they're engaged in executive function, how do you defend that from a constitutional position?
And that's going to be challenging.
So the oral argument is upcoming. I'm not sure if we know yet whether the Solicitor General will be arguing, but you mentioned the foreign policy components of the FTC. That wasn't a big part at all of the government's brief in this case. Do you think it might figure more prominently in the oral argument?
I think that it could.
It certainly did in the tariffs case.
And I think that to the extent you have some justices trying to say there's narrow executive authority, I can see other justices bringing up, wait, we've got some key foreign affairs things going on here, and isn't that purely executive? Doesn't the president need to be able to control the FTC because of those foreign affairs? I can see why the Solicitor General thought, look, this is basically a sure thing because they are suing civilly to enforce the law.
Right.
You can't get any more executive than that. But I do like the foreign affairs component because it shows how important it is for the president to control the FTC.
How narrow do you think the Supreme Court decision will be? Because if they focus too much on the foreign affairs piece of it, that may not affect the National Labor Relations Board or the Merit Systems Protection Board or some of these other cases that are sort of being held in abeyance, waiting to see what happens in the Slaughter decision.
So I think the Supreme Court will be fairly narrow with their decision, but I think that they will be broad enough that it covers most of the other agencies with some exceptions. So possibly the Federal Reserve.
Because they have the Cook case coming up behind it, so they can sort of
they can kind of
hold
kick that to the side. Yeah. But I do think that they took the case not just because Humphreys has needed to be killed for a long time, but because of what the lower courts are interpreting Humphreys to kind of put a constraint on the executive. So I do think it's...
So you think they'll completely overturn it for that reason, to make sure the lower courts don't misapply it anymore going forward?
Exactly, because they have been. They've been misapplying Humphreys, saying that it says stuff that it didn't say, ignoring subsequent cases that have narrowed it. So I do think that they're going to do it broad enough to prevent the lower courts from misapplying it in that context. But I still think there's going to be a few unique agencies that they're going to hold off on.
What happens if the court reaffirms Humphrey's executor? I hate to think about that possibility. But
I honestly don't see how they could. When you look at the concurrences and dissents over the last decade, I do not see that happening. Maybe what they would do instead is say, well, you can't reinstate. But all that's going to do is punt, and then they're going to have it right back there. I don't think they would have taken it on an expedited time frame if they weren't ready to finally put an end to it.
There's been enough percolation on this issue.
Yes.
You think they might be ready to,
there has
sort of go whole hog on Humphreys?
Yeah, there's been more than enough percolation. They have no need to wait any longer on this.
Okay. Any final thoughts about either the briefing or the argument or something else that you might be looking for?
Yeah, I think that we might be surprised that it's going to be a more, not unanimous, but close to unanimous decision, because you just can't reconcile enforcing a law as being non-executive. So I think that we might be surprised on what the final vote comes down, but I don't think that there's going to be a chance that Humphreys survives this. I just don't see that happening.
Commissioner Slaughter is out of luck.
Yes, absolutely.
Well, you heard it first here on Courtside Commentary. Margot Cleveland, thank you so much for being with us and sharing with our listeners and viewers the stakes of this case and what they should be looking for at the Supreme Court.
Thanks so much, Mark.